Hello.
Hi, Ahmed.
Hi.
Ahmed.
Can you hear me?
Yeah.
Can you see me actually?
Yep, we can see you.
Yes.
I cannot see myself. Rarda, we cannot see
Yes.
you. I cannot see. No,
I
I
can
can.
see you.
Okay.
Yeah,
Okay.
I can see you.
Okay. So, what's the plan?
So the webinar has started and people have joined, and we're just giving a couple of minutes for a few more people to join, and then you can kick off with the introductions.
Okay.
Hi, everyone. We'll just kick off in a couple of minutes. I'm sure you heard that update. Ahmed, did you want to start, and then people can join as we get further along?
Yes, but I feel maybe HCT, there's something wrong. Is Charlotte here? Can she reaches out to them? Because I don't see attendees here from HCT. Because we have 75 registrations, so I'm afraid there's something wrong with the link or something.
Okay, I'll drop her a message. Lucy says that the link is working. She's just checked. So
Then let's start.
okay.
Okay. Good afternoon. Good afternoon, everyone. I'm Ahmed Saleh. I am a partner and I head the Innovation Patents and IP department of Al-Tamimi and Company law firm. As some of you may know, Al-Tamimi and Company is the largest law firm in the MENA region. We have presence in 17 offices in 10 countries in the region, basically in all the GCC countries, in addition to Iraq, Egypt, Jordan, and Morocco. We are over 90 partners and 350 lawyers and more than 450 legal professionals. We are a multi-practice law firm. Basically, we are one-stop shop in the region, offering legal services to our clients. And among our practices is innovation, patents, and IP, which is a very strong practice in the region here. Next slide, please. Next slide. So we're pleased to present you a topic today about and which is of a very big interest to the business community today, because it relates directly to all the transformation that is taking place inside the country, in the UAE, and in the wider region, and actually globally. With all the rise in emerging technologies, artificial intelligence, all the economic changes taking place, you will find that innovation and knowledge are within the core of these transformations. Basically, companies today, in order to thrive and in order to be competitive, will need to incorporate technologies and innovations to distinct themselves from competition, as well as you'll find an increasing number of entrepreneurs and startups coming up with the new ideas, with the new technologies, with the new innovations, either to find a place on the market with their new applications and technologies, or to disrupt existing industries or existing ways of doing things. And when we speak about new solutions and new technologies, it means immediately that you want to think about how to protect these ideas and how you want to make sure that all your efforts you've put in, investments, money, efforts, time, creativity, are all of those associated to you, and you make sure that the returns on your investment is associated to you as an owner and as a contributor or inventor or creator of these solutions and these ideas. And this is what intellectual property is about. And here I want to give the floor to my colleagues, both Amina Rao and Raghda. Both are lawyers within the 3IP department, the innovation, patents, and IP departments. Okay. To you, Amina and Raghda. Thank you.
Yeah, sure. Go on, Raghda.
Okay. Good afternoon, everyone. This is Raghda Abdelazim, an IP associate at the 3IP department. I will be presenting the first part of this session, focusing on the general aspects of the IP protection in the United Arab Emirates. Intellectual property is crucial for safeguarding your product designs and ensuring that your innovative ideas remain protected. Today, we will delve into the various aspects of IP protection, particularly in the United Arab Emirates, and provide you with insights on how to effectively protect your product design. Let's take a closer look at the main legal vehicles available for protecting the innovations in the United Arab Emirates. As you can see, please, Amina, can you switch for the previous slide?
This one?
Yeah.
Oh, sorry.
Yeah. Through this diagram, there are several key forms of intellectual property that help safeguard your creative and innovative work. All are protected under the Federal Law 11 of 2021. Here at the center, we have the core of your creative efforts surrounding. There are 5 main types of legal protection: patents, trademarks, trade secrets, copyrights, and industrial designs. Each of this legal vehicle plays a crucial role in comprehensive IP strategy, ensuring that various elements of your innovations are adequately protected. By leveraging protection, you can secure your creative assets, maintain your competitive advantage, and foster an environment of continued innovation. Now let's focus on patents, which is one of the primary forms of intellectual property protection. Patents are mainly designed to protect the inventive concept of your creation. This means that any new and useful process, machine, manufacture, composition of matter, or any new and useful improvement thereof can be patented. But to obtain a patent, certain conditions must be met and available in this innovation. These conditions include the novelty, inventive step, and the applicability to induce this innovation. It should be non-obvious, useful, and your innovation also must be new. It means that it has not been disclosed before to the public before the filing date of your application, and it must involve the inventive step that it's not obvious for anyone with the knowledge and the experience in the same field of the patent. So once you grant a patent, and once you have these certain conditions in your innovation, you can grant a patent, and this patent grants you provides you with a monopoly over your invention for a period of up to 20 years from the filing date of the patent. This exclusive right allows you to prevent others from making, using, selling your invention without your consent. As no one can use, exploit by any means without your permission any of your rights over this patent. Obtaining a patent requires some formal registration process. This involves submitting your detailed patent application to the relevant authorities, like the patent office in your country, and you must then submit your application, which includes the claims, defining the scope of the invention, and description on how to make and use this other formality and legal documents through this application. It's so important also to note that the patent protection is territorial. That means that your patent will grant you the protection in the country that you applied for the application. It will not automatically provide you with the protection in all the other countries, but in case you need this protection, you must file for the patent in each jurisdiction where you seek protection, or use the mechanism such as the Patent Cooperation Treaty, the PCT application streamline process. Furthermore, the patents are a powerful tool to protect your innovative ideas and securing competitive edge in the market. By understanding and leveraging the patent protection, you can ensure that your inventions are safeguarded and that you can capitalize your intellectual property of all your applications. Now let's discuss the key characters of the trademarks. We will jump into the trademarks part. As you may know, that the most known type of IP protection is the trademark. The trademark protects a logo or a mark. This means that trademarks are used to safeguard the unique symbols, words, designs to distinguish a company's goods or services from those of others. It ensures that the consumers can easily identify the source of the products that they are purchasing, making sure your quality of products is the one. There are some conditions that must be met to be able to grant your logo or your mark a trademark, or to be granted. This typically involves the mark being distinctive, not being generic or descriptive. Also, these conditions must comply with the Sharia law and shouldn't mislead the public. When meeting these conditions, then you will be able to have a successful registration and protection of your trademark. The trademarks are protected for 10 years and can provide you with a perpetual monopoly if renewed, as it can be renewed for similar periods, unlike patents, which have a fixed term. Trademarks can last indefinitely as long as they are properly maintained and renewed periodically. But the patents are only protected for the 20 years since the filing date. Here in the trademarks, this allows the company to continue protect their brand identity over the long term. Protection period is 10 years, but you can renew for similar periods in most of the countries. In some countries, it may be protected for 15 years, other may be protected for 7 years, but in most of the countries, they are protected for 10 years and you can renew your protection. Is the registration required? Yes, you must register your trademark to enforce your rights. While common law rights can exist, registering your trademark with the relevant authorities, such as the United Arab Emirates Trademark Office, it provides you with a stronger protection and legal advantages, including the ability to bring a lawsuit in a court, or enforce your rights regarding any infringement of your trademark. Also, the trademarks offer a territorial protection like the patent. This means that you can register your trademark within the geographic area where it's registered, and a trademark, if a trademark is registered in the United Arab Emirates, so it's protected in the United Arab Emirates. But additional registration would be needed if you would like to extend this protection for other countries. Also, there are some unions in like the OAPI and the ARIPO. Those unions allow us to file for one registration, and it will extend your protection for multiple countries. So with one registration, you can have multiple protection in multiple countries, but this is not the case in all the countries. It's just for some unions, as I mentioned, like the OAPI and the ARIPO. In summary, trademarks play an important role in protecting brand identity and safeguard the logos trademark provided. Also, they offer long-term and territorial protection through proper registration and renewal. Now let's move to to discussing the industrial designs. Here the slides here outlines the key features of the industrial design protection. The industrial design protection protect the 2-dimension or 3-dimension ornamental or aesthetic features that includes the visual aspects that gives a special appearance of a product, such as its shape, pattern, colors, which can be either 2-dimension or 3-dimensional. Here the main thing here is on the appearance of the product, the ornamental feature of the product. But to qualify this protection, there are also some conditions that must be met. It's likely the design must be new, not previously disclosed to the public. It also must be it must also adhere to the public order and not violating any principles of Sharia as the trademarks and patents. Also, the industrial design is considered novel unless it has been disclosed to the public by publication, use, or any other method prior to the date of application date. So those industrial designs shall not be deemed as being disclosed to the public as long as such disclosure is made within a year. So unless this, your application is safe, your application is protected. Also, your industrial design applications grant a monopoly over 20 years protection from the date of filing. This means that the design owner has exclusive rights to use, commercialize the design for a period of 20 years and prevent the others from copying or imitating the design without their permission. Do we need to register the application? Yes, also we need here to register the application. This involves applying for an industrial design certificate with the relevant authorities too. But once you have the registration certificate, the design is legally protected. As long as the design is novel and meets the required conditions, it can be protected. It's also important to note that the industrial design protection doesn't cover the technical or functional feature. The protection is purely for the aesthetic aspects that appeal to the eye, not for any functional or technical aspects of the product. It's just for the appearance of the product that we would like to protect. Like the fashion design, the design of a bottle, the design of whatever the product is, but we are protecting the outer appearance, not a technical feature in this product. This also it also applies to a wide variety of products. As I said, this includes everything from consumer goods to electronics, textile, packaging. We have a lot of examples we will delve through in our next slides, but once you register your design, it's protected with a certificate. The certificate is a proof of your design registration, and the rights are granted to the owner of this application. Industrial design protection helps you to preserve the unique visual aspects of a wide range of your products, ensuring that the designers can benefit from their creative efforts by preventing any unauthorized copying or imitation. Now we will get through the trade secrets or the undisclosed information. The undisclosed information shall also enjoy protection pursuant to the provisions of this law. The trade secrets are designed to protect secret information. This includes formulas, recipes, practices, process, designs, instruments, and a lot like patterns that are not generally known or reasonably reached by others, and that provide a competitive advantage to the business that holds the secret, like the KFC, the KFC recipe. There are certain conditions that must be met to qualify this to be protected as a trade secret, as the information must be genuinely secret, meaning it's not known to the public or those within this industry. It's not easy to get those information. It's not mentioned to anyone. It's not available to the public. Additionally, reasonable steps must be taken to maintain its secrecy. This can include measures such as confidentiality agreements, secure storage, and limiting access to this information by any ways. In this case, the registration is not required to protect this undisclosed information, unlike patents or trademarks, which require formal registration with the governmental authorities. But trade secrets are protected as long as they remain confidential and the necessary conditions are met. This provides a potential indefinite duration of protection as long as the information remains secret. This is a trade secret and protected as undisclosed information. To summarize this, the trade secrets offer a vital way to protect valuable confidential business information without the need to register those secrets. However, it's essential to ensure that the information remains secret and the adequate measures are taken to safeguard its confidentiality. Now let's turn to our attention to the copyright, which is crucial for protecting the creative works. Firstly, the copyright grants exclusive rights for owners of original works. This means that the creator of the original work, such as a book, mobile application, music, artwork, film, has the exclusive right to use, distribute, reproduce that work. All these rights can also be licensed or transferred to others through the ownership of those rights. The copyright protects the expression of the ideas, and it's important to note that the copyright does not protect the ideas themselves, but rather than the unique way those ideas are expressed and interpreted. This can include literary works, musical composition, visual arts, and more. The term of copyright typically lasts through all the lifetime of the creator and also for 50 years after his death. Although this can vary depending on the type of the work and the jurisdiction, but mainly it's the term for the protection of the copyrights. This long duration ensures that the creators and their heirs can benefit from their work an extended period. And one of the advantages of the copyright is that an automatic right, meaning once the protection is granted, as soon it means that there is a protection granted as soon as the work is created. Once you create this work, it's protected unless it must be in a fixed tangible form. However, the registration in this case is possible and can provide, and it's important, it's not only possible, but it's important to provide additional benefits such as the easier enforcement and the ability to claim your statutory damages in some jurisdictions if you want to claim your rights from anyone protecting your those work. Despite being automatic, there are certain conditions that must be met for work to be protected by copyright. This work must be original, meaning it must be created independently and have at least a minimal degree of creativity. It must has the minimal degree of this creativity, and it must be fixed in a tangible form and medium of expression, such as being written down, recorded, captured. It also must not falls in the public domain. It also cannot be any mathematical or scientific formula or facts. In summary, the copyright protection is a powerful tool that provides the creator with exclusive and economic and moral rights to their original works, protect the specific expression of ideas, and offers a long duration of protection with the possibility of additional benefits through this registration. I hope this overview has provided the clarity on the distinction between different type of protections. And now I will let Amina go over through the real life applications we can get over through together.
Hi, everyone. Thanks for joining today. I know that was a lot of information, and it's hard to kind of picture how these rights apply in daily life. So what we're going to do now is just take you through some general examples and talk you through what aspects could be protected. So product design exists in many industries, like, there's cars and home design, technology, user interfaces, fashion. Like in every aspect of these industries, there are IP rights that can be protected. So we're going to pick a few examples and then just kind of work through them so you understand what aspects could be protected. So one of the ones we picked was tech, mobile applications, and GUIs. So patent law would protect the innovation, and in the case of technology, the functional aspects that differentiate it from other products on the market. And within, for example, a mobile phone, like the screen function, the touch screen, how does the camera work? Does it fold? That technology, anything new that doesn't exist in the market, you could use patent law and file for a patent to protect it. In terms of the actual user interface, you could use industrial design, because the appearance of it could be protected through that. The software that's made in making mobile applications or any sort of computer software is automatically protected under copyright. So you can utilize copyright law when protecting that aspect of your invention. So there's a range of applications of IP when you look at technology. And Kareem is a good example. I think, Ragda, you wanted to say something about that.
Yeah, it's a very good example. As Careem is a Dubai-based application, it began as a ride-sharing application, but now it offers a numerous service like their cars and buses. There are several IP protection can be interpreted through this application as they are protecting their Careem logo as a trademark in 10 countries. I think in more than 10 countries. It also their graphical user interface can be protected through the product design as an industrial design. The source code of the mobile application also can be protected as a copyright. So there are many ways and different ways of protection can be applied to this example, and a good one. So in all ways, they can protect their name, their brand, their logo, and their source code of the application, their design of the application and logo. So I think,
Yeah. And when we say like the user interface, like if you look at the picture, essentially when you're making the application for this, you write down like, okay, you use the green color and there's a code and this is the shape. And so you go into quite a lot of detail on how it looks. So you can actually protect that interface under industrial design law. Architecture, another good example. So I'm sure these two buildings are iconic enough for you to know what they are, but the Burj Al Arab and the Burj Khalifa, they're these amazing buildings, and industrial design can protect like the configuration and shape of these. Copyright protects architectural works, and therefore it's protected under copyright. Patent law may have been relevant if there was some sort of really interesting manufacturing technique, or they used a new type of material when building these. So it really depends on what elements you want to protect and what can be protected under law. And if we look at the Burj Al Arab more closely, like the shape of the sail, the Burj Al Arab trademark is protected in numerous countries around the world. And you may have seen disputes about unlicensed memorabilia being sold. So they had the Burj Al Arab trademark on it and they were selling it, but there was no license in place, even though the trademark was owned, obviously, and registered. So these kind of disputes and issues can arise for right holders. And that's why it's really important to understand, what should I protect? What should I register? How is it going to be used? And the bigger your business gets, I mean, I know a lot of people in the audience are probably at the very early stages, but if you get it right from the beginning, then it's easier to enforce your rights when there are issues. Fashion is another one. So the design and aesthetic appearance can be protected of clothing. Patents may be granted for a new material, like if you come up with something that's really sourced from renewable energy, or there's a new way to make the fabric, you could patent that. The patterns or the prints that you put on the actual clothing itself, that could be copyrighted, and it would be protected under copyright. And if you have a logo, like a Chanel bag, for example, your logo is protected trademarks, and then the shape of the bag would be protected under industrial designs as well, could be.
Yeah, another example, and it's a very good example. It's the Muzan trademark, or the Muzan brand. Muzan is a UAE-based luxury fashion brand. It has two main products, the traditional clothing abaya and the fragrances. Also, they can protect their IP rights through many ways. They are already protecting their logo and their trademark in more than a country. Furthermore, they can protect their the bottle shape of their fragrances as long as they have a lot of designs of their bottles. They can protect it as an industrial design and have their industrial design rights. Also, the designs of their abayas and their the apparels and fragrances may be also carrying the geographical indication of the United Arab Emirates. The pattern and the design of the abaya and of their clothing may be also protected as a design. So if they have also using a mobile application for this business to order from, or the website, they may also protect the source code of the mobile application as a copyright, as we mentioned before. So there are many ways to protect their brand and the rights in this regards.
Okie dokie. So we've gone through the main rights. We've gone through how they apply in real life situations. And now we're going to talk a little bit about what the value is in these rights and how they help your business and what you should do in exploiting these rights. So why should you bother with registering IP or being aware of it and knowing your rights? First and foremost, it secures like a competitive advantage. It basically prevents people from copying what you created. And that is a strong reason why people file patents and trademarks, because they don't want people copying it and taking advantage of something that they've worked on, put their ideas and investment into it. It helps you commercialize your IP. So if you have an idea which is protected and you want to basically get more parties involved, you want to obtain revenue from a new invention that you've created, then the way to do that is to commercialize your IP. And the way that you do that is by registering your patent and then entering into licenses or partnerships and other revenue generating opportunities. Also, in terms of investment, if you are looking for investment, especially in the early stages of your business, if you have a strong IP portfolio, you're registering your rights, you're able to meet whatever criteria for patents or industrial designs, then you're able to show investors that we are committed to the research and development we're carrying out. We believe in our inventions. We're registering these inventions. This is what you would be getting if you invest in our organization. And then it builds brand reputation. And this is kind of a long-term goal, because if you're building a company, you should have a brand associated with that. Slowly and surely, you develop IP that relates to your brand, whether it's a particular product or clothing or whatever it might be. And then through that, you build a reputation for your brand. And so everyone will know that if I pick up a Dyson vacuum, it's going to be good. It's a trusted brand. We know that it's going to work well. And it takes time and investment to get to that stage, but that's the end goal. So, I mean, this basically summarizes what I'm saying. So if you essentially register your rights, you can exploit them, you can license them, you can generate revenue, you can enter into transactions with other parties to help you invest more in your IP, create new products or get more information from other parties, and then come together and create new products, investment, and then litigation is kind of a last resort. So in the event that you cannot prevent copying because you've registered and someone is copying your idea, you can always resort to enforcement options to try and protect those rights that you have invested so much in obtaining. So what should you do? You've got a new business. You have decided to register some IP, and now you're growing your business. What is it that you should start off by doing? And I think one thing that we always suggest to our clients is to develop an IP policy in the beginning. So everyone within your organization knows, what do we have to do here? What are our responsibilities? What are the obligations of confidentiality, as Ragda mentioned? If you have confidential information, you need to make sure that it stays confidential. And then a lot of patents and industrial designs, there's a novelty requirement. What that means is that no one can know about it. So employees who are tasked with helping or creating certain IP, they need to know what their obligations are in that. So an IP policy is basically a general document that you provide to an employee. Like, we value IP in our organization. These are the things that you can do. These are the things that you shouldn't do. If you create IP, this is who will own it. This is how we'll commercialize it. And it sets out all of those rights and obligations within that IP policy, so it's clear for everyone in your organization. Educate employees, that kind of links with the IP policy, but also you can invest a bit of time in telling them what IP is relevant to, why it's important to your organization, and then make them more invested in actually creating that kind of value for your business. Track and register your IP. We've kind of already explained this. Obviously, keep track of what you're developing. You can do a lot of research and development, but if you're not converting it into actual rights, then that value and that investment isn't coming back to you. So it's really important to do that. And registered rights are so much easier to enforce than unregistered rights. And so it's always important to make that a priority for your business as and when you can. And then slowly, once you've actually built your business up and you're getting in the market and you've created this new product, you monitor for infringement, and then you take the necessary action to protect yourself. Now it's a wide range, and this is where you would get legal advice, which is the last point that I have on the list. And that's essentially, I have this patent, this person is using the information from my patent and they're doing it without my permission, what can I do? One is to send them a letter and say, stop doing that. I own this patent, or otherwise I will bring proceedings against you. Another one that a lot of our clients actually employ is like, let's get in touch with them. Let's see if there's a collaboration opportunity here. Let's see if they'll enter into a license and pay us a licensing fee. And then at that stage, you can think about what to do next. So it's always important to get legal counsel involved. We can help you register your IP, protect your IP. When you actually get into these commercial situations, it's something that we can help you draft up and make sure that you're protected in whatever scenario that you're in. And then I just very briefly, I have a few examples of different agreements that you would enter into when you get to further along in your journey. Confidentiality agreements, NDAs, a lot of the times when you're going into an investment discussion or you're basically reaching out for research and development opportunities, anything like that, you will disclose things about your products, and the other party that you're negotiating with will also want to disclose things about their products and see what kind of aspects you can collaborate on. Those discussions should be covered by confidentiality. There's no guarantee that these initial discussions will result in an agreement in the end. So you want to make sure that they are bound by confidentiality obligations, so there's no risk of you losing any of your IP rights. IP transfer agreements, technology transfer agreements. Again, this is a bit further down the line. You would think about this if you wanted to transfer or assign any of your rights in the context of, let's say, a merger or your company being acquired in the future. You would look at how you would transfer that. And this technology transfer isn't limited to just IP rights. It's also includes know-how. How do you run the business? What confidential information is important? So you would have to have lawyers involved at this stage to make sure that everything is transferred over, if that's your business that's being transferred, or if you are acquiring a small business, let's say, to make sure that you are gaining the rights that you need to build up your business. Joint development contracts, that's essentially collaborating together, making sure that there are positions in place in terms of who owns what, who's bringing what. And at the end of the day, if we create a new IP right, who is going to own it? How are we going to commercialize it? How are we going to protect it? And what are we going to do in the future? And then licensing, essentially patents, trademarks, whatever it is that you want. This can be with any business that wants to use your IP. You enter into this agreement, and this can be an exclusive license to just one person in a certain territory, or it could be to a range of people, depending on the type of license. And then you obtain a licensing fee, and then you can also get some royalties. It depends on the terms of the contract. Franchising, that's also very much down the line. You build a successful business, you want to build other franchises. What is it? What are the provisions that need to be in place to allow another party to do that? Software development contracts, as your business grows, you may need certain software to implement particular inventions. You may hire consultants, and what needs to be considered, who is going to own that software that's developed, how is it going to be utilized and exploited? All of that needs to be covered very clearly within the contract itself. Okay, so we wanted to leave 15 minutes for questions at the end. And I think someone commented that you can't open your microphone, which is fine because this is a webinar, but please feel free to add any questions to the Q&A, and then we can try and go through those. And that's it. We're at the Q&A section. I don't know if Ahmed wanted to add anything, or Ragda, if there's anything else you wanted to add.
Thank you very much, Amina and Ragda. No, all is good from my side. Thank you.
Okay, so one of the questions we have is regarding the protection area. If the patent is filed in the UAE only, this means the IP is not protected in other countries. Yes, that's right. It's territorial. So when you file in the UAE, it's protected in the UAE. If you want a patent in Saudi, you need to file in Saudi. And that's something that our team does for clients all the time. So they pick the most strategic locations and then they file in those countries. Does PCT patent filing provide the required protection worldwide, including the UAE? No, PCT filing does not do that, and you still have to file specific applications in the territories that you would want protection in. So feel free to type any other additional questions in the box, and then we can answer them. And if there are no other questions, then I think we can end it there. Do you assist with IP applications? I think the question here is in terms of drafting it, if that's the question, yes. Usually what we do when an inventor comes to us and say they've created some sort of patent or design, then we have a very detailed first meeting with them. We have patent attorneys on our team, and they sit down with you and they talk you through the invention itself, what would be protected, and they can help you draft up the patent as well. Okay, I think that is the final question.
No, we
Okay,
have another
there's
one.
one more.
Yeah.
Does that involve having a contract to assist? Does that involve having a contract to assist with the IP application? I'm not sure I follow that. Does that involve having a yeah?
Perhaps what the question is here. Okay. Yes, I mean, working with us as attorneys to support you with the IP protection, we do put into place an agreement between us, including the terms of engagements. So if this is what's meant, say yes. If this is not what you meant, please clarify. And yes, we do have a full team of IP attorneys, patent attorneys, and commercial attorneys. We help you throughout all the process, from the protection to the ideation, protection, registration, enforcement in front of the courts, transactionals, contracts, agreements, all of this. What is the typical cost for filing an application in the UAE? You want to give it, Amina, you want to handle that?
I think it very much varies. I mean, like, I think if you were particularly concerned with this question, we could share our cost of fees, like the general fees that it would cost throughout the different stages of the patent, and we could share that with you over email after the call. I think that might be more useful.
And generally speaking, a patent isn't something which is cheap. It involves some costs, and there are ways that we work with entrepreneurs and startups who obviously have more limited resources than larger companies, and maybe wants, to postpone some of the fees for later stages at the time they bring on board investments and they kick off the operations. There are ways and strategies that can be put in place to preserve your rights in the meantime and postponing some of the substantive fees for later stages. And a PCT application is one of them. And the PCT application, filing a PCT application, you actually buy 2.5 years before you're requested to go and file specific applications, as Amina mentioned. This, enables you to buy time, and the time you have to get more investments into place, and the time you kick off operations and business revenue start to kick off in your company. So average-wise, a patent, if we're talking about a regular patent application, in each country of protection, you're talking in average around between preparation of the patent application, the submissions, and the registrations process. You're talking about $15,000 in each country where you want to protect. If you're going the full scale. If you're filing for a provisional application, which is kind of, a quick and cheap way of putting into records your invention, the time you get something more developed in due course and converted to something, a more regular application, that's in the range of $3,000, $4,000, $5,000, for example, and you can buy sometimes around 1 year before you're, required to go and convert into a regular application. I hope that answers your queries.
Okay, I think that we can end it there. Thank you very much, everyone. Perfect. He says, yes, it does. Or she, whoever it is, it's an anonymous attendee. Okay, well, thank you, and we'll end it there.
Thank you all.
Thank you all.